Chapter 3 involves an individual's constitutional protections. So we're going to be talking about the Constitution and its protections in the next three. There's actually three videos. I broke them down in smaller chunks covering the applicable language in the Constitution as it relates to criminal law. So we're going to discuss a criminal defendant that has a number of protections that are codified in statutes and the law, but the Constitution also provides certain protections. And as we talked about earlier, we were talking about sources of law in the Constitution. The federal Constitution applies in every case, anywhere. And of course, the states have their own constitutional protections, and they're free to add more protections for individuals. But as I indicated and as we discussed, they can't conflict with the federal Constitution. So just to recap, who's protected? Anyone who's on U.S. soil is protected under the constitutional protections. And from who or from what? That is governmental action. It's the government restricting our rights in the Constitution. So keep those two things in mind. And there are two ways we do this. There are two types of constitutional protections, I should say. The first one, that's the one we're going to spend the most time on, is where we have a challenge to the constitutionality of a statute or an ordinance that has been passed. Touched on this a little bit about what's going on in the South, changing the abortion laws. We're going to talk about Roe v. Wade in a moment. But challenge the constitutionality of the statute or the ordinance. And there's two types of attacks. It can be attacked based on how it reads. It's unconstitutional on its face, whether it's vague or broad. It can be challenged as unconstitutional as it is applied, and it could be challenged on both grounds. If you remember the example from an earlier video, the video games, it's illegal to distribute violent video games or violent movies to minors. That was a statute that was passed in California, and it was a statute that was deemed unconstitutional on both of those grounds. We already discussed where there's issues, where it's vague, but also the case that it involved, and we're going to talk about the First Amendment, but it also was unconstitutional as it was applied because it violated a fundamental right, the right of free speech, and that is the ability to have your art in the form of whether it was a video or a movie to be distributed. When you're not allowing it to be distributed to minors, you're restricting my right to free speech. So in that case, both of those challenges were made, and both of them were successful. The second challenge is to the procedures. That's something we're not going to be delving into, but this is a challenge to procedure that occurs during a prosecution, right? What happened during the arrest and interrogation, during the trial? Was it proper? That's the other challenge. Was it unconstitutional? We are going to focus on number one. So let's go through some cases here. Give you a little peek. These two cases involve flag burning. In 1989, Texas versus Johnson. That's our criminal case. See the state? This is a state of Texas. There was a law that made it illegal to burn the flag. Right, that's the fancy language in the statute, but there was a law that you could not burn the flag. And during a protest, somebody, Mr. Johnson, was burning a flag, and he was arrested, and he was prosecuted, and there was a guilty verdict, and he appealed. And he appealed all the way up to the United States Supreme Court. This was a case the Supreme Court heard because the constitutional issue was this a violation of my right to free speech? And the court said, yeah. So as applied, hence this statute was rejected as unconstitutional because burning the flag at a protest is free speech. So in that instance, this was deemed unconstitutional as applied. So in no such haste, in the following year of that decision, the United States, the Congress said, well, we're going to pass a law that says anyone, this is the law, whoever knowingly mutilates, defaces, physically defiles, burns, maintains on the floor or ground, or tramples upon any flag of the United States shall be fined or imprisoned or both. So Congress passed this law. I don't know if Congress thought that they were above state law, but they passed this law, and Mr. Aikman, also Mr. Johnson was involved, by the way. The date that this law took effect, there was a protest, and there was some flag burning, and both Mr. Johnson and Mr. Aikman were arrested and tried, found guilty, and the case went all the way up to the Supreme Court, and the Supreme Court said, didn't you get our message from Texas versus Johnson? You can't make a law that infringes on a fundamental right of free speech, and burning the flag is free speech. So I show you both of these cases because the first one was a state statute, the second one was a federal statute, and both deemed unconstitutional as applied, as it applied in against a fundamental right. Not on its face. It's not very vague. We get it. It says you can't burn the flag. There was nothing vague about these statutes. It was as applied in violating a fundamental right. Other cases involving fundamental rights, Roe v. Wade, we're all very familiar. This is the punishment for abortion. It doesn't say doctor, but it's the person who actually conducts the abortion that can be arrested and spend 5 years, 2 to 5 years in prison for any person who procures an abortion. And this statute, there's other parts of it. Anyone who helps with an abortion, there could be a fine up to $1,000. And the court reviewed this statute, and they said it was unconstitutional on its face and as applied. The court ruled that a woman's liberty right, a right to control whether or not she is pregnant, is stronger than the state's interest in the fetus life up until a certain point in the pregnancy. And then it goes on to describe additional reasons why abortion should not be illegal. And over time, this law on abortion has changed. And we're not going to go into the laws of abortion. I'm just using this as examples of statutes that have been deemed unconstitutional, that they were challenged on their face. And you can see how the system works. So that was another challenge, a big challenge to a law that was passed. That was a state law, by the way. And then we have Brandenburg versus Ohio. We're going to talk a lot more about this case in the next topic, which is free speech. I think we need to cover free speech because there have been a lot of laws that have been passed and it's been criminalized, free speech. So we're going to delve into that a little bit. But for purposes of whether or not the challenge, showing a challenge, it's unconstitutional as applied and on its face. It's a statute in Ohio that prohibited individuals from advocating crime or violence or any other unlawful methods of terrorism as a means of accomplishing a political reform. Basically, it's advocating against the government. Let's narrow it down. That's what it was. And while that might sound something that should be criminalized or at least, contained, this involved protests from the Ku Klux Klan. This is from 1959. And their marches and, their literature and what they stand for. And in that instance, that particular law in Ohio was deemed unconstitutional for a number of reasons. Who does it apply to? And on its face. and on its face and on its rights, a fundamental right, advocating the overthrow. So what are we attacking here? Free speech again. You're entitled to speak about advocating overthrow of the government. This makes an extension of that. You may have heard the term, quote unquote, clear and present danger. We're going to talk more about that in the next slide. But these are examples and types of statutes and how the courts look at it and review to deem whether or not a law is constitutional or unconstitutional. The concept that a court uses, what it's called, is judicial review. So if a court, let's use the Supreme Court because they're the ones that are usually looking at the constitutionality of a statute. What they're doing is they're conducting judicial review, and what they do is they do this weighing, this scale. Think of the scale again. On one side of the scale is the government's interest. What is the government trying to protect here versus what the person's right is, one's interest in that protected right. So that's what they are looking at. Now, rights come from the Constitution, spelled out in the Bill of Rights: right to free speech, right to religion, right to assemble, right to bear arms. There's a list of rights that we are entitled to from the government, but that does not mean that the government could never have some restriction on those rights. For instance, the one that always pops into people's heads is right to free speech. Do you have an absolute right to free speech? No, because the example is, can you go into a crowded movie theater and shout fire? No, because you put people in danger. So there are times, even though we have this protected right of free speech, on the other hand, the government has interests. It may be public safety, it may be health and welfare, but when we're talking about a fundamental right that is spelled out in the Constitution, the court is going to do this judicial review, and they are going to scrutinize that governmental reason for limiting that protected right. We call that the strict scrutiny test. They are going to pick it apart and look at it under a fine microscope to determine whether or not that government interest should weigh more than somebody's constitutional right. So in that example about free speech, that's the weighing test. Free speech, protecting a crowded movie theater or crowded locations from somebody shouting fire in the middle of it, is to protect people's health and safety. And while protecting health and safety is not always a valid reason in that particular interest, and there's more to it to that, and I'm actually going to talk about it when we talk about free speech, you'll see how the strict scrutiny will break down relative to that. When there is a challenge that is based on equal protection clause, which is an extension, we'll call it an extension of the Constitution. It's not one of the amendments. The test is a little different. The test is rational basis test. Does the government have a rational basis for doing what they're doing? And this allows the statutes to discriminate if there is a rationally related legitimate government interest. We're not going to spend time. I'm going to go over the Equal Protection Clause, tell you what it is. The most one we are going to be dealing with crimes is going to be the ones in the Constitution. So we're going to be dealing with that strict scrutiny test. So the question, just to go back to using Texas versus Johnson, the first flag burning case, the government's compelling interest. What do you think the government's compelling interest was with passing a law not to burn the flag? To protect a symbol of our country? Should that weigh our ability to have symbolized speech, i.e. I'm protesting this war, so I'm burning the flag. The court said no, that wasn't enough. But there are times, like can they pass a law that says you can't burn the flag, period? I think I'll just burn the flag today. There's no real political speech surrounding it or any sort of speech intended. I'm just burning the flag for the sake of burning the flag. Maybe. Like I think I said it in one of the other videos, there's 48 of the states have flag burning statutes. So are they enforced? Not likely. At least it's not enforced in New York. So, but there are times the government can regulate, as I indicated, and we're going to start talking about those in just one moment. Their regulations come under something called time, place, and manner. Again, I like using free speech because we all can relate to that. We already talked about you can't yell fire in a crowded theater, but also let's talk about, you're standing on a street corner handing out flyers and you're screaming through a bullhorn your opinion. You are free to do that. It's a public sidewalk. You are free to do that. Can you do it at 3 a.m.? Probably not, because there's probably some ordinance that says it's 3 a.m. and people are sleeping and it's a government interest not to disrupt the neighborhood. That could very well be valid. Can you do it at 3 in the afternoon? Sure. So there are times when the government can regulate. Our next topic we're going to roll into is some legislator prohibited powers that are set forth in the Constitution. Then we'll go to free speech, and then we'll talk about some other amendments.